Okay, good afternoon, ladies and gentlemen. The Metropolitan Board of Zoning Appeals is now in session for its regularly scheduled meeting of November 21st, 2013. I'm Joey Hargis, and I'll be presenting the cases for review in today's public hearing. At this time, I would ask everyone either turn off or silence their cell phones as not to disrupt today's meeting. Quite honestly, you probably don't have any service in this room anyway, so you're just killing your battery. The procedure will be to introduce the case record as the Codes Department has it on the wall here by means of a PowerPoint presentation. We'll present site plans, photographs, and maps of the properties involved in today's cases. We'll also present any letters that we have in support or opposition to a particular case, as well as any correspondence from other Metro agencies. At the conclusion of my presentation, the applicant will come first to the table, along with any persons in support, and if there's opposition to a case, the board will hear from those parties after the applicant speaks. After the opposition speaks, the applicant has a period for rebuttal. In the board's rules, the board provides cases without opposition 10 minutes to present their case. In a case with opposition, the board provides 15 minutes for each side of a case to present their testimony. So if there are multiple speakers, be sure to divide your time before coming up. All section numbers I refer to today come directly from the Metropolitan Zoning Code, which is Title 17 of the Metro Code of Law. Title 17 was adopted by Metro Council and became effective January 1st, 1998, and applies to the entire jurisdiction of the Metro government. I'll dispense from reading individual sections unless the applicant or opposition requests that I read them. A copy of the zoning code is entered into the record, and I have a copy there at my desk should any parties wish me to read particular sections of the zoning code. The zoning code requires that these proceedings be taped. Therefore, it's imperative anyone wishing to address this board to come forward. Push the button on the microphone stand. Your microphone will have a red ring around it like mine does. It means you're ready to speak. When you get done, if you would, please turn that off. And we'll go on to the next person that wishes to speak. It should be noted that it's found anyone presented false or misleading testimony to this board that may have affected the board's decision. Any approval may be revoked at a later date by means of a show cause hearing. The board will go through all cases set for public hearing today, and after each case, the board will discuss and vote on that case. The board is vested with the power to act on these cases as outlined in Section 1740-180 of the Metro Code. The code requires that 4 members of the 7-member board be present to constitute a quorum. The code also requires that you have 4 affirmative votes to grant your application. I have 5 members present today. You need 4 of these 5 members to vote in your favor to grant your case. If you fail to get all 4 votes today, your case will stay on our agenda for the next 30 days. I'll have 1 meeting in the next 30 days. That's December 5th. These members are allowed to change their vote. The 2 members who are not present are allowed to watch the proceedings on YouTube, read the paper record, and become eligible at December 5th. If after December 5th's hearing no one changes their votes, you still do not have 4 votes, your case is deemed denied by operation of law. In the event, for some reason, that I only have 4 members hear your case today, if you fail to get all 4 votes, your case will automatically be reset for a new public hearing. We're currently taking cases for January 2nd's hearing next year. The appellant or any aggrieved property owner may request a rehearing within 60 days of today's public hearing. Further, the appellant or any aggrieved property owner may appeal this board's decision to Chancery or Circuit Court within the same 60-day period. After that time, 60 days has elapsed, the board's decision is final and no further action may be taken. If you're an applicant and your case is granted, it is necessary for you to come and pick up the permit for which you've applied. You can begin working again on those permit applications in our office where you filed beginning on Monday. A reminder, next week, we are on the 3rd floor for just 3 days next week. Thanksgiving holiday comes, the next week we'll be down on the 1st floor as you enter the building, and you'll turn to your right to come to our offices. So we're relocating and are very, very happy about getting off the 3rd floor. If you're an applicant and your case is granted, you have 2 years from today's date to pick up the permit for which you've applied. So this board's approval, you've got 2 years to exercise your permit. If you take out your permit, barring any time limits placed by this board, your case is granted forever. Mr. Chairman, I submit that all cases were filed in proper order. Applicants were notified by certified mail as required by the zoning code. All affected property owners within 300 feet were notified by first-class mail, and a legal ad was published in the Tennessean as required by the code. Before we begin, I do have a couple of preliminary announcements. The case on page 1, Vanderbilt University, the request at the corner of Highland and 25th is deferred until January 2nd by the applicant. That will be heard at the end of that agenda. And then case 2013-116, Mr. Ed Clay at 209 South 5th Street has requested a deferral until our next meeting, which is December 5th. That case will be at the end of the December 5th agenda. With that, those are the only preliminary announcements I have. Are there any other announcements for the board? Okay. The board has...
Is there a reason that that's at the end of the agenda as opposed to the beginning?
Their deferral.
They request it?
Their choice, yes, sir. If you guys defer it, we'll put it up front. The board has a consent agenda, and a board member reviews the record in each case prior to the hearing, and if, in their opinion, the applicant meets the criteria for the application they've requested, and they feel that testimony in the case would not alter material facts, they recommend the case to the remainder of the board for approval. I'll now enter into the record those cases that have been recommended for consent. If there's anyone here opposed or have questions regarding cases, please raise your hand. The case will be removed from consent and heard in its regular order. The first case I have recommended for consent agenda is at the top of page 2, Sage Construction, LLC, the appellant of the property located at 311 54th Avenue North, requesting an addition to a nonconforming structure and a variance to in side setback in the RS 7.5 district to construct a one-story addition with a screen porch to the rear of the residence, referred to the board under section 1740-180D and 1712-020. Is there any parties present opposed to case 2013-115 at the top of page 2? Have any questions or anything? Mr. Chairman, seeing none. The narrowness of the lot necessitates a need for hardship in this case. I was remiss to say at the beginning of this that Chairman Whitson reviewed the cases for consent today. The next case recommended for the consent agenda is case 2013-117 at the bottom of page 2, Odyssey Construction, the appellant in Enix, Tennessee, the owner, LLC, the owner of the property located at 1823 10th Avenue South, requesting a variance in the street setback to construct a new single-family townhome. That's referred to the board under section 1712-030. Are there any parties present opposed to case 117 on 10th Avenue South? Mr. Chairman, seeing none, the shallowness of the lot necessitates a need for hardship in this case. Next recommended for the consent agenda is case 2013-118, Odyssey Construction at 1000 West Grove Avenue, requesting a variance in street setback in R8 to construct a new single-family townhome on that lot. Any parties present opposed to case 118 on South West Grove Avenue? Okay, Mr. Chairman, seeing none. Again, the hardship here is the shallowness of the lot.
Joey, I have a question on that.
Yes, sir.
I'm not sure why those are two cases when they're attached, a single attached.
When originally filed, they were separate parcels, and then the parcels have been combined on that, and that's why they were separately advertised that way. And actually, we're going to permit them separately as well, so that way the variances will track with the building permits.
They don't have to have one for the attachment?
It'll be where the attachment occurs, each unit will be permitted separately. So that physical connection is just part of the building permits for each. The next case recommended for consent, case 2013-119, Mr. James Creason, the appellant, owners in common at the Brownstone at 5 and G, the owners of the property at 1702 5th Avenue North, requesting a variance in the masonry wall requirements to authorize completion of the site plan approved by this board under 2011-28 without the masonry wall. You have a recommendation in the file from the urban forester recommending approval of this request. The wall construction, in his opinion, would damage the root systems of adjoining properties and would harm the trees adjoining as well as the trees that would be planted in this buffer yard. So he's recommending to you all that this case, that the fence be waived, the masonry wall be waived in the case. Are there any parties opposed to case 119 present? Okay, Mr. Chairman, seeing none, as stated by the urban forester, the hardships given to the unique situation of the property necessitate a need for variance. And finally, the last case recommended for consent, case 2013-120, Linda Burnstead, appellant and owner of the property at 9479 Highway 96, requesting a special exception to AR 2A to construct indoor doggy play facility for the existing dog facility approved by appeal case 2001-57. I know there were some folks that had questions that if you
be consistent with the current plan, and we'll make sure that that gets in there. With that, there's no objection to it, and I told these folks that I would make that announcement on the board.
Mr. Chairman, you fine with amending with those two conditions?
Absolutely.
We'll enter those into the order. Okay. And with those two conditions placed, Mr. Whitson recommends that case for consent to the remainders of the board members.
We have a motion. Is there a second?
I'll second it.
Okay, we've got a motion. We've got a second. All in favor of the consent agenda? Aye. Any opposed?
Okay.
Passes.
If you're here for cases 118, 119, 120, I'm sorry, doing this backwards, 117, and 115, your cases have been approved. Just follow up with the Codes Department beginning on Monday for your permits. With that, the Board of Zoning Appeals is adjourned for today. Thank you.
I would like to say to the applicant and the neighbors, thank you for working it out. It's always a lot easier than hearing 30 minutes to then work it out. Thank you.